everyone. This is Gaston Crew for this week's Markman Minute. You can check out our content on MimesisLaw.com under the Intellectual Property tab, along with all the other great content on Mimesis. This week, I wanted to talk about something that we addressed in our note, and we've talked about in the past with respect to big deals for investors with respect to patent litigation situations. And once again, our topic is going to be Kyle Bass and his assault on the pharmaceutical industry. But this time, what makes it what we think this week's issue of interest is that actually the empire has gotten a chance to strike back. The first IPR, or inter-parties review, that was filed by Bass was against a company called Acorda, targeting the patents that protect its #1 revenue drug, Ampyra. And due to the vagaries of the scheduling in the USPTO, Acorda had the opportunity now to file its first response to Bass's IPR filing. So on one level, this response is interesting just because it presents Acorda's response to Bass. But on another level, we think it's interesting because we think it's a harbinger of what other pharmaceutical companies might try to do in terms of the threat presented by Bass. And depending on how the Patent Office treats this particular response and this particular IPR, that could be a bellwether for whether or not Bass's strategy of filing these IPRs, shorting the stock associated with the company, and hoping to profit when the generic competition comes into market and the share price of the target company goes down, whether or not this whole scheme will work. So why don't we take a look and think about what Acorda has tried to do. And one of the things right off the bat that we found interesting about Acorda's response is that they went right to the heart of Bass's strategy and challenged it in front of the patent board. Their argument right off the bat is that Bass is using the IPR system for an improper purpose, and that neither Congress nor any of the stakeholders ever anticipated that an IPR would be used as a weapon to short the stock of a pharmaceutical company, by clearing and by trying to clear the way for generic competition. We thought it's interesting that they chose to go with a procedural attack on Bass first off, as opposed to addressing the merits of the actual petition that Bass filed. Why is this important? It's important that they're challenging Bass's quote-unquote strategy, because if the patent board buys the argument and agrees to dismiss Bass's petition against Acorda for this procedural, strategic, improper purpose reason, then that doesn't bode well for the rest of his IPR filings. And we can imagine that every other one of his targets is going to use this as the first argument as well and say these filings were done for an improper purpose and these petitions should be dispensed of without even addressing the merits of whether the patent being targeted is any good or not. So on the one hand, that we thought was very telling. We don't, strategically there was no reason for Acorda not to make the argument. It may be one of their, whether or not it's a strong argument, we'll see depending on how the board treats it. But it was interesting that they led off with this, and when we consider the potential ramifications for the other IPR filings, it's very important to continue to monitor how the PTO is going to respond. Separate from the kind of procedural, strategic, Bass is a bad person using this process in an abusive way argument, Acorda also tried more, I would say, technical arguments, trying to attack the substantive arguments made by Bass in his petition. Now, here, obviously everything's going to be decided on a case-by-case basis. Every patent's going to have its strengths and weaknesses, and every piece of prior art that Bass uses against a particular patent is going to have its strengths and weaknesses, just like in any other IPR proceeding. So it's going to be interesting to see at some level whether or not Bass's system works in terms of finding the good prior art to kill patents. And I think it's important for investors that are invested in any of these strategies, and for Bass's investors themselves, to see whether or not the strategy is actually working. So if the patent board dismisses the procedural argument and says, look, we're not going to take a position on whether a third party is able to file an IPR. We're not going to get into the motivation of that third party because the statute says that IPRs are available to any third party, and the patent board says we're not going to try to distinguish winners and losers based on the motivation for how they're using the IPR process, then I think investors are going to be very interested to see, is BASS doing a good job on the merits? And this first IPR institution decision that we expect to come within the next couple of months is going to be an important, I think, issue for investors to consider going forward. So things to keep in mind going forward. A, we want to see whether or not the patent board gives any traction to this argument that BASS is working for using the system in an improper way. B, we want to see whether or not BASS is successful in getting this particular petition instituted against Acorda. And C, we want to keep our eye out on the other BASS targets that may have their responses come due over the intervening months, and see what types of strategies they use to counter the threat of BASS's IPRs. That's it for this week's Markman Minute. Again, please check out our content on mimesis.law.com. Under the Intellectual Property tab, you could read our weekly newsletter, the Markman Note, check out our prior videos on this and other situations, and check out all of Mimesis's great content. My name is Gaston for Markman Advisors. Thank you. See you next time.